Hello, it's Simon here again, and thank you for joining me. This lecture concerns the preparation and thinking about precedents and clauses that are going to be used in the EU assets will. As normal, we will talk mainly about Spanish assets wills, by way of illustration. In this lecture, we talk about the clauses and a number of concepts. In a later lecture, we spell out the clauses you will use and where they will go. In fact, we write a Spanish assets will. We're going to start off with the importance of realizing that there is a difference as regards the content of the Spanish assets parallel will between there being or not being a UK parallel will. For the purpose of this lecture, we refer to an actual will that was written around 10 years ago when this activity was relatively new. Whilst a great deal of research had been put into what these Spanish assets, French assets wills should contain, it took some time before the first clients of any of our members operating as Willwriters Association EU Willwriters experienced a death. It soon became apparent, once the first deaths had occurred, that the 5-page will, which is in your hands now, though it worked perfectly, contained typical English will content, which was not applicable in Spain. And whilst it would have been irresponsible not to include those clauses in the parallel UK version of this will, there really was no need to repeat them in the Spanish version. 1, because what was required could be borrowed from the English version, either automatically or by the use of a single line. And 2, they were meaningless and of no assistance to the notary in Spain, notwithstanding that they would have been assistance to the probate court in the UK had there not been a parallel English will. This will shows those powers as a reminder to us that this is a matter, a concept, that has to be taken into consideration at the time instructions are taken. If there are to be grants of probate in the UK or Ireland or Scotland, there will almost always be a parallel standard English will with all of its normal executor and trustee powers for the court to grant to the executor and trustee. If, however, there is no guarantee that there will be a simultaneous parallel will for the British Isles, then the Spanish will has to contain more of these British Isles clauses, albeit simplified and kept to a minimum. So it has to be a matter of personal judgment for the will writer, which eventually reflects itself in one of two ways. If there is more of the typical British Isles will clauses in the Spanish assets will, then the translation paid for by the beneficiary, or the recipient of the gift, although we've never actually heard anyone complain about that, given its small cost by comparison with all of the savings achieved and the heartache removed, nevertheless that translation will be greater and will cost more. Or, which is a little worse, the notary is left without as much information as he would have liked to have had, which is something we'll look into a little more closely in this lecture, but which may call for there to be more paperwork, more translations, which is unhealthy. So as a concept, the amount to put in or not put in is of some moment. But let's look at it through the eyes of the probate court. Where a testator writes two parallel wills, particularly if they're dated at the same time, where for administrative purposes that the judge will fully understand, it's divided into 2 or 3 in order that the second and third grants of probate can be taken to France or to Spain, whilst the first grant of probate is used in the UK. As far as the probate court judge is concerned, this is one will, albeit divided into 3 parts, as said, for sound administrative purposes. He or she doesn't need to see the trustee or executor's powers repeated. If a single executor is given powers by the testator, then they're given once and they apply to the entire estate. The only purpose of adding those powers or any other information of this nature into the Spanish assets will be because the notary in Spain requires to see them and know of them. Now, as regards executors and trustees, Spain doesn't have them at all, so there really isn't very much point in putting long powers into both the British Isles will and into the Spanish assets will, unless there is a risk that needs to be taken account of that there won't be a British Isles. Now, that might be for 2 or 3 reasons. It might be that the British Isles will gets lost, or is defaced, or is deliberately destroyed. Perhaps, for example, the person, having had a holiday home in Spain for many years, decides to emigrate to Spain and destroys their British Isles will. If we could see into the future and know that that was going to be what would happen, then we would put most, if not all, of the powers into both the British Isles will and the Spanish assets will, which would substantially increase the translation costs and complication. But there is, of course, another way, which is to make this information known to the client and to stress how important it is that even if there is already a British Isles will in existence, which has been written perhaps in the last year or 2, it should be replaced, uncomfortable though that will be financially, by 2 parallel wills, and there should be a failsafe copy of those wills, and either the original or the failsafe should be stored in Sentinel will storage. Now, it may be that as you listen to this lecture, you are not familiar with or have seen the Failsafe Will concept. That concept was originated by the Willwriters Association chairman of many years, Michael Barry, who was unusually a solicitor, who became a barrister, and who then became a university lecturer in law. You should have received a package of Willwriters Association documentation, will makings and envelopes and so on, witness information, instructions, and a failsafe will statement. And so you can probably work out from that what occurs. The failsafe will is included in one of the lectures, but it is further down the track, as is Sentinel will storage and other association services to its members. All that we need to know at this stage, if you can imagine it, is that the failsafe will is exactly what it sounds like. It means that when we sign, witness, attest a will for a client, we can do a second copy which becomes the original, and the identical will signed and witnessed seconds beforehand become the failsafe. And if the original is lost, then the failsafe can be produced out of storage and used to obtain probate. And so let's just summarize that concept. The primary concept of a Spanish assets will is that it should be as small as possible, as simple as possible, as translatable as possible, and restricted only and entirely to matters in Spain. But in shrinking it, by comparison with its British Isles parallel, we have to take account of the possibility that the British Isles parallel might not be there. And if that is a concern, then we should be sure to include in the Spanish asset wills at least enough for it to successfully obtain probate in the British Isles, whereby the executors and trustees can perform their duties. Far better, though, is to ensure that there will be parallel wills, both available side by side, by use of a failsafe and will storage, leaving the client to have the original wills if they want, and to lose them if they want. And with that done, then the Spanish will can safely be shrunk to its absolute minimum, which will save time and translation costs. Now let's move on to content. So for the rest of this lecture, you'll need the Lavelle will in your hand, which is written on the Willwriters Association software using its catalogue of clauses, which is tied into the instruction booklet you will have received at least one copy of. The opening clause is relatively straightforward. It incorporates the property address in Spain along with the date that the will was made. Now, a will does not have to be dated in its opening paragraph, and this may be something we will have to look at as regards the will writing software that you use. In fact, a will does not have to be dated anywhere within the document, so long as there is at least one date appearing on the document, more usually showing the date it was signed. It is, however, the Napoleonic Code tradition, and it does make sense for the wills to be dated in the first paragraph. That date, however, is expressed as the date that the will was made, i.e. meaning the date that instructions were given, or the date when the thought processes were completed and put down on paper, which might be some days or even weeks away from the day it was signed and witnessed. It's therefore perfectly possible, and so long as the logic of it can be followed, and it's perfectly reasonable, for the will to have two dates. The date that it is made tells the probate court when the thoughts that led to the will were expressed, and the date of it being signed and witnessed reflects the time in between instructions being given to a will writer and the will being prepared ready for signing. People sometimes fly into a fit of panic when a will has two different dates on it as a consequence of the above, but there is no problem with that. The second clause, I have gone down my will with a pencil and given each clause, which is separated by lines of spaces, I should say, separated by correction. I have gone down my copy of my Lavelle will and have put a number in pencil alongside each clause, which is then separated by a space for the next clause. The second clause is crucial to the concept of parallel wills because it says, I hereby revoke all former wills and codicils made by me in respect of my property in Spain, and I further declare that. This statement tells the probate judge immediately that we are dealing in this case with Spain, and that anything that has gone before it is revoked, and that will include any previous parallel British Isles wills making reference to something in Spain, or any Spanish wills, or any Spanglish hybrid wills. All of those become wiped out, revoked, by the second clause. In other words, if a judge is faced at some point in time with a British Isles will written in 2014 by a local British Isles will writer, which mentions property in Spain, and is then asked to make a grant of probate to a second Spanish assets will, or any EU assets will, that you have made in 2015, this second clause enables him to override and ignore anything that is said in the original British Isles will that mentions Spain. That, however, is not a good situation, and whilst your clients will probably or possibly resist rewriting a British Isles will so that you can write an exact parallel of the post-Brussels IV EU assets will, it is easy from this illustration alone to see why that makes sense and can lead to complete clarity. The third clause, which is A in brackets, confirms where the testator is domiciled for the purposes of this will. Now, both residence and domicile are rather complex issues that have a great deal to do with tax and not a great deal to do with wills, though that has been changed slightly by the introduction of Brussels IV, which includes as one of its qualifications that the testator has been habitually living in the country where the will is made, someone from the British Isles habitually living in France up to the point that they die. But that does not affect British Isles wills. In brief, domicile reflects a country to which you belong as a consequence of your birth or your father's birth, though that in itself can be a little complicated and is the subject of separate lectures. But primarily, your domicile is what is on your passport. And even if someone has dual passports, so one of them is a British Isles passport, then this clause 3 is correct as it stands. Residence, however, is where you happen to be living at any one time, and impacts upon which jurisdictions you make payments of taxes to, though it has now been complicated slightly, as I said, by the inclusion of the word residence into the Brussels 4 rules. Well, clearly a query can arise if there is a British Isles will for someone who states they are domiciled elsewhere. So there's no point in complicating the issue. Anyone has the right to write a British Isle will if they own property in the British Isles, or if they're a resident of the British Isles, meaning that they've been living there continuously for a while, or if they and or their father emanate from the British Isles. So in any of those situations you can say that they are domiciled in the United Kingdom for the purposes of this will. The fourth clause, which is B, reaffirms and expands upon what was said in clause 2, and because this is going to be a British Isles last will and testament rather than a Spanish testament, it follows the British Isles tradition of incorporating both movable and immovable property into a single document, which we've outlined elsewhere in another lecture. Whereas the tradition in the codified laws of the Napoleonic countries is to deal separately with most movable assets through their codes relating to marriage and other issues, leaving the testament generally and simply to deal with immovable assets, property, buildings, land. Then clause 5, which is C, further lays down the foundation in concrete as regards which of the parallel wills, or two wills where they're not in parallel, deals with what. This clause removes the possibility of there being any query arising as to whether some aspect of the parallel EU assets will might be intended to deal with property that's in the UK. For example, take a client who has a £100,000 yacht or speedboat that is normally berthed in a marina in Spain around the corner from his villa or her villa. But on the day that he or she died, that boat was berthed in a UK port because they had come over to do Christmas shopping. This is an actual case I'm referring to. The boat is now in the UK. And so when you look at the two parallel wills, each saying that they deal with the property of the respective two countries, the boat which was intended and normally spent its life in Spain is now in the UK, and so would and did come under the distribution of the UK will, whereas it had been intended as a gift to a female friend of the testator. It actually ended up being received by his British Isles based wife. As an EU asset will writer who's alert to your task, where it seems a possibility, you should talk around these things. What a well-written parallel will might have made clear in that situation was that any vessels or vehicles normally situated in Spain would be subject to the Spanish parallel will, no matter where they happened to be in the world at the time of the testator's death. Now this is an illustration of a situation which could never really arise in an ordinary British Isles will of the type you have been writing. It's something that entirely relates to Spanish asset or French asset wills, and so it's a concept you're going to have to take on board and make part of your thinking. It is the concept of not taking anything for granted and trying to be as clear as crystal. Now you might be thinking as I'm speaking that you don't have very many clients who have fancy motor cars or yachts or speedboats or aeroplanes even. But as a consequence of you becoming an expert in this field, you are going to be moving more in the circles of those people who do have property assets abroad, a house in the British Isles, a villa in France. They're going to recommend you to their friends, you're going to form relationships with estate agents in the British Isles who sell those kinds of properties, and by and large, those people, it stands to reason, if they have two properties, are going to be wealthier in general than the run-of-the-mill clients who live up the road from you in the British Isles. And so you are going to come across people who have Ferraris and yachts and speedboats and even aeroplanes, and you need to switch your thinking into gear when you're taking those instructions. Clause 6 is D, and you will not need me to tell you that revocation is one of the most dangerous events in the whole of will writing. There are large, if not huge, numbers of people each year in England and Wales who unwittingly revoke their wills by getting married, not aware of that slightly quirky rule set in 1837. There are a great many tangles created by people writing their own wills who fail to revoke previous wills, in which event the previous wills and the latest will all stand pari passu. They all stand alongside each other. If they're not revoked, then they both count, which makes for great fun at court. And there are people who write wills in Spain or in France with Spanish abogados whose notary system does not create the same revocation issues, because it is the latest notarized will that is the only will capable of obtaining probate, irrespective of the word revocate or revocation. Whereas every year in the British Isles there are many situations to be untangled when a will written in an EU country or anywhere elsewhere in the world that includes revocation turns out to unwittingly revoke not only the previous EU will, but also accidentally the previous British Isles will, and so on. This clause states for the avoidance of any doubt that this will does not revoke a British Isles will, and of course it is in the reverse in the parallel British Isles version. Clause 8 might be thought of as belt and braces, and even to be over gilding the lily, because what it says will have already applied from the previous clause B. But it is an echo clause that is in the opposite direction to what is in the British Isles version, and it gives the probate judge or a notary one nice single line to hang a hat on, being that none of my movable or immovable property in Spain disposed of in this will is disposed of in my British Isles will. These echo clauses, which are included even when the point's already been made clear, are nevertheless included so that in one single short phrase a probate judge or a notary has it. Though this one at E is in effect almost an echo of the equivalent B in the parallel British Isles will. A parallel EU assets will appoints an executor, or if female an executrix, notwithstanding that there's no such animal in Spain or anywhere in the Napoleonic Code. This won't offend the notary, who realises of course that this is a British Isles will, and notaries who live in areas where there are a large number of English-speaking people are also broadly aware of the nature of English wills and how they operate. And just because assets are situated in Spain or belong to somebody who's in Spain, it doesn't necessarily mean that there won't be a British tangent of some kind calling for an executor or a trustee to act, which don't exist in Spain and France, etc. Where, for example, gifts are given to children who are underage, which will be required to be moved from Spain to the British Isles and held until that person comes of age. This is the work under the British Isle system of an executor or trustee, and if one isn't appointed, then the chain falls down in quite a technically complex way, as Peter Harris, a barrister specialising in this field, makes clear in his report, which deals with the situation in France in the wake of Brussels 4 and his fears for people who have their wills written by someone who is not sufficiently expert. Hence the next group of clauses dealing with executors and trustees as if this were a standard British Isles will. The bulk of these, beyond the appointments themselves, are however superfluous where there is a parallel British Isles will, which brings us to another principle of parallel EU asset wills, which is borrowing. As regards the flurry of clauses down to X1V 14, these can all be borrowed from the British Isles parallel will, either by simply assumption, because as we have said, the probate court judge will treat these as one will, one document effectively, or for the avoidance of doubt by way of a clause saying something along the lines that my executors and trustees shall carry out their duties exactly in accordance with the instructions contained in my British Isles, by which we mean UK or Scottish or Irish will. This clause isn't going to give any concern to a notary, even though he cannot see what's being referred to, because there's no such person as an executor or trustee in his world, so it doesn't matter who or what is said should happen in the case of them. So now we jump down quite a long way to the 26th clause, which is the one saying, I wish my trustees to employ as their Spanish probate and property law advisor Ángeles Franco of ASG Abogados. Because in most situations, the person left to deal with these EU assets will be living in the British Isles, and almost certainly will have no idea how to move forward without obtaining some help from the will writer or the Willwriters Association or a local abogado or a combination of. And so it is a very good idea for the testator to name one or several local English-speaking advisors whom the folks back home can call upon for assistance in English. It is, however, not advisable to name these local advisors as being officers under the will with any role. That could complicate things considerably, especially if they had moved or were no longer in practice or had died. It's perfectly sufficient to name these people simply as an option for the beneficiaries, the executor or the trustees, to take up if they want to and no more, but not to name such people as having any power. Moving on to number 29, the entire process of death certificates and funerals in the generally hot Napoleonic countries is entirely different from that in the UK. It's not unheard of for people to be buried on the same day as they die, or certainly within a day or two or three. It's almost completely unheard of, other than where there's some criminal investigation taking place, to have people kept in morgues for several weeks whilst funerals are organised and people assembled. And consequently, the British Isles, relatives and friends of people who die in Spain are frequently left unable to attend a funeral or become engaged in some sort of battle to fight for time to be able to organise a funeral. So much so that there are private services, air ambulances basically, available who sell services to expats and other foreigners to return their body to their homeland for a homeland funeral, all of which should be probed. But here, the clause that I leave all funeral arrangements to my executor is about the only one that can apply unless they are to be flown home, because there's little point in stating any preference for a funeral in a Napoleonic country, for one, and secondly, as you will know, these statements of preferences have no legal power and can be overridden by the executor in any event. And thirdly, the will is unlikely to even rise to the surface, to be found and available to be read before the funeral has taken place. So, all in all, that statement is for good order, and just for certainty, and to repeat, though I'm sure you will already be aware that the only part of a British Isles will that's been correctly drawn up that is not legally binding and that can be overridden are the funeral directions. Such things as I want my body to be buried at sea are all very nice and might be possible, but on the other hand might not be possible, and so there has to be power to the executive to change those. And so finally, the will is completed in the usual way, and of course signed and witnessed by the testator and two witnesses who are in the room at the same time, who know from his demeanour that he is or she is not under the influence of any body or anything. He's not drunk. The witnesses watch the testator sign and should hear him or her say, "I have read and understand this will." The testator should then watch whilst the two witnesses sign, and each witness should watch each other, and that document is then legally binding and is a valid instrument in the British Isles, where it one day can be used to apply for a grant of probate. So in this lecture we have covered several concepts which in a way need to be listed in your mind. The concepts are of brevity, simplicity, translatability. Then there is cross-borrowing and echoing. And then there is issue surrounding movable assets in Spain, France or wherever, which might become moved inadvertently, or if not inadvertently then at an inconvenient time at the time of the death of a testator. There are the names and contact details of English-speaking local advisors to be considered, and there are funeral arrangements. All of these things are concepts that will be different from the wills that you have been writing in the British Isles. And on that note, we will leave this lecture and move on to the next. Good day to you.